All right, to discuss this further is legal expert Mpumelelo Zikalala from Zikalala Attorneys. Mpumelelo, good evening and thank you very much for your time. So a significant move, half of the shortlisted candidates are non-judges. Now this is specifically for the Constitutional Court post. Now there's a long history around the shortlisting of judges versus non-judges in the Concourt, with the very first Concourt bench post-apartheid comprising of a significant portion of non-judges in an effort to somehow break away from the past where those with experience as judges would have been white and predominantly male under apartheid. Briefly talk us through this history that makes the composition now of these candidates very significant.
I think you highlighted a very important point to say that it was the start of the very first Constitutional Court. So if you are going to go on a strict criteria of experience, it means that you would have regurgitated the judges that were already on the bench, and there wouldn't be any transformation that would have taken place. The other defect that would have happened is that predominantly the individuals that would have been there are individuals that would have had your lucrative practices either as attorneys or even advocates, senior counsels, and which entry, or there was a high barrier to entry for especially black legal practitioners to be able to participate in that. So in order to open the doors, you needed to relax the rules somehow and make sure that you're able to accommodate a number of people that are going to be there. And lastly, you're dealing with a legal topic which was sort of new in South Africa when it comes to the constitutional provisions that are there of rights and interpretation of such. So you needed to accommodate as much as possible. Now, 30 years down the line, that has changed. But what that signifies is the lack of transformation within the legal sector, the type of problems that you're still being faced with that you were faced with 30 years ago. Then it says, what have you done, especially out looking to the Office of the Chief Justice and also to government to say, what have you done to transform the legal sector or to transform the legal services in our country? It proves that little has been done, hence why you are getting the same results in which we received 30 years ago.
But Chief Justice Raymond Zondo attempted to change things because he announced last year that he'd be inviting non-judges to act at the Concourt and saying, among others, that the judges in the High Court had indicated to him that they were not necessarily exposed to constitutional law matters on a daily basis, which would afford them that opportunity to become constitutional law experts. So would you not say that that was just in an effort to address this very problem of transformation?
It is, but you're not addressing the core of the problem of providing a solution which is going to assist. The solution would be, let's make sure that this work that is Constitutional Court ready or related is given to legal practitioners or black legal practitioners in particular. So you come back to government and you say, you are the biggest buyer of legal services in the country. So make sure that when you issue out briefs, every single brief which is going to go there is going to come up with a specification of saying, make sure that there's a black legal practitioner that is there. Secondly, speak with the Office of the State Attorney. If you go there today, you'd find a number of files that are with them. They'll find a number of staff which are highly overworked, and yet you have legal practitioners that can be able to assist. Why don't you brief them at the end of the day and make sure that they are being exposed to this type of work as you move along? With this solution that you are coming up with, you are not coming up with a permanent solution. It's just an interim solution which is not going to produce the results that you are looking for. Transformation of the judiciary is going to start with the briefs. It's going to start with the Office of the State Attorney being open to all legal practitioners so that they're able to practice. It's going to start with every single government department from your national, provincial to municipalities having a clear direction of how legal briefs are supposed to be issued. And it's going to start with the exact bill that we are waiting for as legal practitioners, which is sitting at the desk of the Minister of the Department of Trade, Industry and Competition, that needs to be signed in order for this type of sort of service and skills training to take place. And then you move to the second phase of saying, whenever they're acting stints, there must be a very clear criterion on how a person is able to act, the number of years which are required, so that we're able to act, so that the doors of acting are open to everyone. Everybody must understand how those rules work. If you have
pardon me for interjecting there. So you have spoken about the exposure of non-judges through acting. And then now you're also talking about the skewed briefing patterns, that here we have a number of advocates that are not necessarily particularly black, that may not be exposed to more complex matters, be it your pension fund law, maritime law, intellectual property law. And you're saying that here it is the state attorney, as the biggest consumer of legal work, that should be the one that prioritizes these black lawyers, particularly women, because we understand that their situation is even far more worse.
Definitely. They hold the pen that signs those instructions. And if you're going to be clear in the manner in which those instructions are then issued, then it makes it good. But then you go a step further and say, go to the provincial and even municipal offices and make sure that each municipality has a clear pattern of how to brief black legal practitioners. If you don't have that, you are going to forever have this problem that you are facing now. What indirectly we are saying is we have failed to transform the legal sector. We're trying to parachute individuals who are now professors to say, go to and sit in the highest cost in the land with no litigation criteria whatsoever, with no any experience as how to litigate in the other intricacies that comes with litigation. And you are saying to them, come and decide in the highest court of the land.
But they've been acting. But they've been acting in the Concord as constitutional law experts. Is that not enough?
But they haven't been litigating in the constitutional court. Litigating in the constitutional court and listening to arguments are two different things. The most important thing is to then say, are they going to have the right acumen when it comes to adjudicating those cases and to be able to listen to legal arguments? If the answer is no, and they're simply going to judge it from a professor-based type of perspective, then you're going to have results which are not entirely in sync with what is happening on the ground. Transform the legal sector, and then you're going to get the results that you're looking for.
Now, insofar as the conversation with some saying that it's more of a debate of what comes first, the chicken or the egg here, that if we're going to push for the level of transformation that you're talking about, you're going to see a lot of inexperienced advocates perhaps being brought onto some of these complex matters, and then when government loses the case, then there's people even on social media that say, you see what you've done. Are you saying perhaps government needs to just have that courage of their conviction to say, allow them to err, but they need to be exposed to these complex matters no matter what? Have the patience to allow for that transformation to happen?
Not at all. What you are saying is that just make sure that when you have a senior counsel, make sure that the junior is black so that they're able to learn experience and to absorb whatever experience they need to absorb from them. Secondly, it's not all complex cases which are going to be issued out by the state attorney or government. There are going to be cases which are going to be easy, and yes, a person, if continue to get those type of pension law cases once in a while, then they're able to gain the experience and also the confidence to go and act the complex matter. But what will not happen is that if you choose and you say, this is a complex matter, this is a matter which only a few individuals can be able to deal with, hence it's going to be given to these individuals, we are going to have this deficit. At the end of the day, there's no training which is going to take place, there's no transfer of skills which is going to take place, and you still find yourself with this problem of not having enough candidates that are going to serve within our benches.
Mpumelelo, thank you very much for your time this evening. That's legal expert Mpumelelo Zikalala speaking to us.